It Today is September 8th, 2015, and it's now 10 o'clock right now on the east coast of the United States, but it's almost afternoon time in Rome. And then at 12 o'clock noon time, Rome time, the new motu proprio regarding the annulment procedure for marriages has been released by the Vatican press office, and in in the Holy Father pretty much has authorized the streamlining of the annulment process for marriages. Now, first of all, to be straight about this, I wish nobody in the world would have to come to the process. I don't care what year or what situation you're living in. It is a tragedy if you even have to use the system for that purpose. But anyway, what I am going to do is the Vatican website had only the text of the motu proprio, the official Latin text plus an Italian translation. So I did a Google Translate for English, and I'm going to read some highlights that what the Holy Father has written. Don't reminder, this is motu proprio, and the official name of the document is actually two. I'm going to read the one regarding the the Latin Church, which is the West. There's the other one that refers to the Eastern Rite Catholic churches, but I'm only going to focus on the letter for the West because that's what most people belong to. It's called Mitis Iudex Dominus Jesus, which is mean Lord Jesus, the gentle judge. Okay? And I'm not going to read the whole entire thing, but I am going to read what I have came up with a translation from Google Translate. And this is unofficial, but you will get the gist once the official English translation goes up on the Vatican website. So there are some bullet points, one, two numbered bullet points. So the Holy Father says some equipped basic criteria have guided the work of the reform. So his item number one, with a single sentence in favor of nullity of the executive, which means, and he says, it is suggested in the first place for nullity of the marriage is no longer in conformity with the decision of the two, so that the parts required to be admitted to a new canonical marriage, but from a first moral certainty sufficient for the attainment of the judge according to the norm of the law. So, which means that you that you do not need a second trial or a review of your case. Now, bullet point number two, bullet number two authorizes for a single judge under the bishop's responsibility. It says the constitution of the single judge, in the first instance, the responsibility entrusted to the bishops in their pastoral exercise of its judicial powers to ensure anyone that who tolerated lacks. So this is not obviously not a correct translation, but basically what bullet point number two authorizes that the Vicar General would be the only judge for all matters in the diocese, and would be the only one authorized to hear the cases in the diocese of where it's taken 3. And then section 3 talks about the bishop as the chief justice of the diocese, in order that the level of a document which is of great significance affect the Second Vatican Council in the end they draw to the decree of them, he may be clear that the bishop in his church diocese in which the pastor and the head is made up, by that very fact to be among Christ's faithful entrusted to the care before a judge. So it is great to hope that the bishop, as bishop of the diocese, in a small signal conversion, offer ecclesiastical structures and the role of the judiciary in matrimonial court offices are delegated to leave. This is especially valid for a shorter process which is established to settle the case manifestoris nullity. And number 4, the process of shorter. In fact, the ordinary course of execution, giving up marriage to emerge some kind of process is shorter in addition to the existing documentary as present into those cases which the accused applied for a marriage nullity case is particularly evident support arguments. We, however, had noticed that in as so far as the judgment of the principle indissolubly in marriage in abbreviated form can be brought forward from the crisis, the judge in such a process to the end would have to be judged him to compensate. I have made that with the bishop, with Peter, who is in unity of the Catholic faith and discipline of the office of pastor, than those who on most account of his guard against it. Okay, and then section 5 is the appeal to the Metropolitan Archbishop. If you are in a case originated in a regular small diocese. And then section 6 has the duty of the Episcopal conferences of the countries, the Apostolic Seal which inspired bishops, and the faithful share in the restoration with the relationships between them, except for the one with the help of a thorn in the individual bishops' conference that have come the process of the reform of marriage to fulfill. And then section 7 is an appeal to the Apostolic See. So effective December 8th this year, the Immaculate Conception, so the following canons have been revised right now. And so this is near the back of the canon law book. Canon 1671, okay, section 1. The matrimonial causes of the baptized pertain the right to the ecclesiastical judge. Section 2. The cases concerning the mere civil effects of marriage belong to the civil magistrate unless particular law provides that in those same causes, if incidentally and subordinately, can be heard and decided by an ecclesiastical judge. Okay, and so which that means a pretty much means that where it is recognized, an annulment is pretty much equal to any type of separation or divorce. Now, Canon 1672, in cases concerning the nullity of marriage which are not reserved to the Apostolic See, the following are competent. First degree, the tribunal of the place in which the marriage was celebrated. Second degree, the tribunal of the place in which either or both of the parties have a domicile or a quasi-domicile. And third degree, the tribunal in the place in which, in fact, most of the evidence is to be collected. So it can, that's not much of a change. Canon 1673, Section 1. In each diocese, the judge of first instance for the cause of nullity of marriage not expressly expected by the law is the diocesan bishop, who can exercise judicial power personally or through others with accordance of the law. So that's that part does not change. The bishop is the case of first instance immediately. In Section 2 says the bishop is to appoint within his own diocese the diocesan tribunal for causes of nullity of marriage without prejudice to the faculty of the bishop which have access to other closer to the diocesan or interdiocesan tribunal. So pretty much they're saying that, so what the Holy Father has just legislated is that several dioceses can have one tribunal, okay? So, and then Section 3, it says that concerns the tribunal, the three judges who used to have to hear the cases. So, and that translation's not correctly. So, and then Section 4 says of this canon, the bishop moderator is, if the tribunal cannot be constituted in a diocese or a nearer diocese, a collegiate tribunal in accordance with Section 2 in the spring causes a single clerical judge who then can be done, and the two assessors of the upright of life, but experts in the sciences, judicial or humane, by the bishop for this purpose. Office approval is based the same single judge, unless it is otherwise evident there are those things attributed to a college to the presiding judge or the penons. For Section 5, for the validity, the tribunal of second instance must always be collegial based on Section 3. And then Section 6 says the first instance appeal is to be made but to the Metropolitan Tribunal of the second instance without prejudice. So, and then the right to challenge a marriage, okay? This is the interesting one. Canon 1674, Section 1. The following are to be qualified to challenge a marriage. 1. The spouses themselves. 2. The promoter of justice when the nullity of has already become public if the convalidation of marriage is not possible or is not expedient. Section 2. A marriage in which both spouses were living can be challenged after the death, cannot be accused of either of, but that cannot be accused of either both of the spouses unless there is a question of validity and necessity of preliminary resolution of another controversy in the canonical form or in the civil form. So pretty much this says, so if you were married for an X amount of time and then your spouse dies, you can still question it. And then section 3 says if a spouse dies while the case is pending, see canon 1518. So now this next article 3, introduction of the case, canon 1675 says a judge before he accepts a cause must have gone to the bottom. Irreparable marriage must be informed so that the common conjugal life is to be restored to be imagined. So, and then 1676, section 1, on the recovery and the libellous has some foundation to rely on him if he deems that the judicial victor that he was at the degree append upon the libellous copy of the notified to the defender of the bond, and if the book has been subscripted by both parties to the respondent, the same was given in term of 15, the petition for opening the chronicles of mind known with regard to their own. Section 2, the perfecto time period is passed. Yeah, so a lot of these here are pretty much revisions near the back of the canon law book. And then section 3 of canon 1678 says, in causes concerning the imponence or a defective consent because of mental illness, a judge of psychological nature, normally, or to use the services of one or more experts, unless from circumstances would appear evidently useless. In all other cases, based on canon 1574. So, pretty much means that if you're mentally ill, you can have a therapy session. That's not justice at all. So, and then canon 1680, section 2 has come up with a time limit. So there is now a time limit to hear. There's now a statute of limitations on hearing cases. So Yeah. And then Canon 1683 says so the bishop is pretty much saying the bishop can expedite the thing, and then if both spouses petition, or pretty much, and then you have to, so if the bishop hears a case, it has to be heard within 30 days now. So that's what it's saying here. Um, yeah. So, and then those are procedure, and then Canon 1691 section 1 says, in this sentence the parties are to be warned about the moral obligations or even civil ones by which they may be bound towards one another and towards their children to furnish support and education of their children. So, in other matters concerning the conduct are to be applied. So the reason why, and then the addendum shows that they're citing last year's Circus Synod in 2014, why this was written. So, yeah, yeah, so, I mean, yeah, so it is pretty difficult with a Google translation, but what I am saying now is that it is pretty much a very streamlined process, which pretty much anybody who asks for one is probably going to get one now, and and that's that. So, and then there's this Catholic Family News article just posted by John Benari, um, shows a shows some bullet points here, which are very more clear. They are that only one case, one hearing, one judge is enough. The bishop can serve as judge, and there'll be, and then ones that are very easy to proceed will, like ones that are obvious, like which basic ones, those are going to be heard like right away. And then the appeal, and but still it is pretty much showing that, because the most likely in most cases there will not be a second trial, it there's going to be absolutely more, and I mean more, abuses in the process.